Hey guys, it's Karalynn and welcome back to the podcast. Hey, I just want to take a minute. I know you might notice our new graphics. We changed the name of the podcast from Quit Getting Screwed to Construction Legal Made Easy. But I wanted to take a second to dive into why I started the podcast originally in 2021 and what that all meant. So the podcast name came from my book that I launched in 2021 called Quit Getting Screwed. Okay, and so where does this come from? So I've been a construction lawyer for 20 years, and one of the big pain points that I saw was commercial subcontractors signing commercial subcontracts that were full of BS, and they kept getting screwed because of it. And it wasn't just that this was the standard operating procedure in commercial construction, that we write these terrible contractors and subcontractors just have to sign them if they want to go to work. But it was also the fact that nobody was saying anything. Like, hey, warning, that 40-page contract that you didn't read and you don't understand is full of terrible things, right? And I saw time after time again of like contractors not necessarily doing anything wrong, but not understanding the contract that they were signing, right? And so the final straw on the camel's back, if you would, was I took a contractor to trial that had done everything right. But because of his contract terms, he wasn't entitled to payment because the owner hadn't been paid because I had a pay when paid clause, and it put him in bankruptcy. And I was like, all right, somebody's got to say something. And so that's when I wrote Quit Getting Screwed and started the podcast as basically a platform that contractors could really learn the legal risks that are in commercial subcontracts. Obviously, the podcast has expanded to other legal ideas, to residential construction, to all the other legal pitfalls that are out there. But this was really the true impetus to starting the podcast, to getting out there, to being the voice for somebody that doesn't understand it, right? And so I just want to you can get the book on Amazon. It's out there. It's not that expensive. But I just want to take a second to kind of highlight the chapters that are in here, so that you'll know what's in here and what's kind of important. So the book opens up kind of where a construction project opens up with the bid. And some of the highlights to understand here are that your bid is a legal offer. Once accepted, you're on the hook to do the work. And so what does that mean? In legal terms, that means you should always do an itemized bid if possible, not a turnkey bid. Because like if you say, I'm going to do all of the AC work in this contract, in this project for $200,000 and you miss something, then you're on the hook to do that extra work you missed. But if you have an itemized bid, this is what I'm going to do for $200,000, then you can say, hey, that wasn't in my bid. I'm not entitled to do that work, right? I don't have to do that work and I'm not going to be charged for it. So, kind of breaking down why the bid's important, spending time on it, all the good things. The next thing that I like to do, this is actually chapter 4, but I like to put it right after the bid, is the scope of work in the subcontract. Okay, you did your bid right, you broke it down. Now a subcontract is being issued to you on that bid that you issued. First thing you have to know is that bid generally does not become part of your contract. So you need to look at the scope of work as if you were bidding a new job and make sure it matches your bid, right? So the bid was your offer. The subcontract is their counter offer as far as the scope of work goes. So you really need to dive in and make sure plans haven't changed, project manuals haven't changed, that would change your scope of work. So very carefully look at the scope of work. I've gotten so many clients that have been bitten by this, that extra work was included in the scope of work that was not in their bid. And like, well, I didn't bid that. And that's fine. You didn't bid that, but you signed a scope of work, with the contract, which the contract is the controlling document, not your bid. So big things there. Next thing to know is usually the subcontract documents are more than just the contract that you sign, right? So usually there's a provision in there. One of the big ones is it includes the prime contract, which is the contract between the owner and the general contractor, which you've never seen. So you should probably request a copy, and a bunch of other things that are in there. So another thing that I highlight in here is subcontractor bonds, when they might be required, kind of the dangers of getting a subcontractor bond if you don't know what they are and how they work. Just a preview. They're not insurance. If your subcontractor bond has to pay out, you'll be on the hook to pay them back. Do not sign a personal guarantee. If a subcontract comes with a personal guarantee, there's no way you should sign it. And that is not industry standard. So you can feel comfortable negotiating that. Prior work and field conditions, how the status of the job and what it looks like, everything from parking to travel. If there's something about that costs you extra, you're not going to be entitled to a change order for it. So know what that looks like. Submittals and as-built. There's some great tips in here about how to get submittals and as-built to approved and make sure they're done right. Daily reports. There's a chapter in here about how important daily reports are, even if they're not required on your project. Hugely important to your internal records. Chapter 9, which is a big thing in commercial construction, pay when paid clauses. This is probably the most dangerous provision in commercial subcontracts. Basically says that you, the subcontractor, have no right to payment even if you did everything correctly until the owner pays the general contractor, which is something you have no control over. So take some time in there and also give some ways around that, like liens and other ideas. Chapter 10 goes over what retainage is and why it matters, why it's withheld from your contract, that 10% normally or 5% on public works jobs. Chapter 11 kind of explains what a lien is, how your lien rights work. The rules are different in all 50 states, but what great protection liens are. Trust funds. This works both at the subcontract level and the general contractor. That funds you receive for a construction project are trust funds, meaning that if you owe somebody and you receive money on a construction project, those are the first payments you make. You can't pay anything else until you pay what you owe on that job, including paying other jobs with funds you receive from one project, like robbing Peter to pay Paul. You can't do that legally. Change orders. This is another huge one in commercial and all construction. Getting a signed change order before you do the work. Otherwise, you won't be entitled to payment. Specifically in commercial construction, reading over the change order provision in the subcontract, who can approve them, when, how do they have to be approved. If you don't follow those specific provisions, even if you have one, it might not be enforceable. Assignments, if you can, assignments, what we're talking about here is most subcontracts generally have the rule that you cannot hire a subcontractor to do your work unless it's approved by the general contractor. I know most people don't do that. Sometimes it's enforced, sometimes it's not, but something to know. Chapter 16 goes over delay damages. What is the delay damage? It's a per day charge for each day you don't finish on time. Obviously you want to know if that's in your contract. A big part of this is making sure the schedule in the project is correct when you sign the contract. If it's not, make sure you get it changed before you sign it. Chapter 17 goes over warranties. Normally a warranty, if you issue a 1-year warranty, you have to realize that doesn't start until the project's complete. It doesn't matter when you're complete, right? And it's also got some tips and tricks in there, how to get paid everything before you do warranty work. Default and termination. This has termination for convenience clauses, what those are and how those work. This has what happens if you're in default and you get terminated, how to prevent from getting terminated, the importance of responding to every notice of default you get, whether it's email, text, not just a letter from a lawyer. So that's a great chapter. Chapter 19 is on attorney's fees and cost. Mostly subcontracts call for the general contractor to recover their attorney's fees. Generally does not include subcontractor recover theirs. So that might be something you want to negotiate to add in. Dispute resolution. What's the difference between mediation, arbitration, courtroom litigation? When do those different phases get involved, and understanding those provisions in your contract? Guys, so what this is I'm not saying you have to negotiate all the provisions. I'm trying to tell you where the risks are, and then you can decide, right? That's my job, is to tell you where the risks are, and you can decide if it's a risk your business wants to take or not. So, I think I wrote this when I was really pissed off, and I think it's worth mentioning. The first line in the introduction is, "Are you tired of being the general contractor's bitch?" That's how angry I was when I wrote this. That's what it feels like when you sign those damn contracts. But, you know, the more people that'll start negotiating these things, the better they'll get, right? You know, what happened back in the day is the general contractor had an attorney draft up a contract that was one-sided for them, right? Thinking that there would be a negotiation. Well, what happened, subs just wanted to get to work. They trust the generals. They signed these contracts and they did not negotiate them. And now they've become the standard. And so knowing how to protect yourself, you know, if you've never had your commercial subcontract reviewed before you sign it, I highly recommend it. We do that here at the Cromeens Law Firm. Not that you want to negotiate, but, you know, we tell you what you should negotiate, give you some tips on, you know, negotiation tactics, other ideas besides what's just in the contract. So guys, this is a great book. You know, subcontractorinstitute.com. I teach all of the 20 chapters on there for free. It's still out there. It's still a free resource you can use if you don't want to read it. But guys, some great information. Also, if you like the podcast and the information that we talk about on here, I highly recommend that you sign up for our newsletter. Our newsletter goes out twice a month with great information, deep dives into termination for convenience clause or lien rights, or, you know, what to do if you don't get paid. So sign up for our newsletter. It's in the show notes. Thanks.